Hello, community. I'm Naomi Anderson and I'm from Aged Care Ready and founder of our wonderful group, Aging Parent Support Group on Facebook. Welcome to our 6th live session. Today we are joined by Renee Cellante from Beaumont Lawyers in Melbourne, and we will be talking about powers of attorney. Welcome, Renee.
Thank you.
Tell us a little bit about yourself and what brought you into law.
I don't know what brought me into law, really. I kind of just fell into it, I suppose. It was a passion. I've been at Beaumont Lawyers for about 8 years now, so been there for quite a while. Worked in various areas, but for the last sort of 3 or 4 years, I've specialised in powers of attorney, wills and estates. So, yeah.
Great. So let's jump straight in, because I know a lot of the viewers out there are eager to hear about what you know. So let's start off by asking, what is a power of attorney?
Yeah, so a power of attorney is a document that someone appoints, and the person who is appointing the attorney is called the principal or the donor, and they appoint a person to make decisions with respect to either their finances or medical decisions on their behalf during their lifetime. So there's all different types of powers of attorney. There's specific powers of attorney, medical, financial, and the agent or the attorney that's appointed is legally obliged to make decisions in the principal's best interests. So.
Okay. And so how does a power of attorney differ from a will?
Yeah, so a power of attorney or your attorney is able to make decisions while you're still alive, but you might not be able to make those decisions on your own behalf because of maybe a lack of capacity, or you might be overseas or something like that, whereas a will is a document that comes into effect after you've passed away. So some people think that an attorney can be an executor and vice versa, but no. So a power of attorney is a document that operates during your lifetime, and then the will obviously takes effect after you've passed away.
Sure. Okay. And so back to power of attorneys, you mentioned earlier a number of different types, but what's the difference between a medical power of attorney and a financial power of attorney?
Yeah, absolutely. So a medical power of attorney is someone who can make medical decisions on your behalf. So it's sometimes also called a medical treatment decision maker. And that person can make decisions such as filling out prescriptions, taking you to doctor's appointments, right up to decisions with respect to surgery, or turning off life support and things like that.
Okay.
That person, or in conjunction with a medical power of attorney, sometimes people also do what's called an advanced care directive, which is a different document again. And that document might outline more specifically the details with respect to your medical care or treatment in the event that you couldn't make those decisions yourself. We usually see advanced care directives in a situation where someone has a more chronic illness or terminal illness, and they have very kind of a specific plan with respect to their treatment, and their GP or treating specialist is the person who would draw up that document, and it kind of sits with the medical power of attorney, but not always necessary. So that's the medical. With the financial, a financial power of attorney usually covers financial and lifestyle decisions. So from doing the weekly shop, paying bills, that day-to-day affair, right through to selling your house, signing aged care contracts, moving into retirement villages, all of those types of things are covered by your financial kind of / guardianship power of attorney, which is that other option.
Okay. And so with the medical power of attorney, you were quite specific with the advanced care directive and things like that. In an emergency situation where it came down to for resus, would that be covered?
Absolutely. So if you were a power of attorney, you're obviously entitled to make that decision on behalf of the person, and the doctor would look to you to make that type of decision. However, some people in their medical powers of attorney might specify in there that they don't want to be resuscitated in the event that a doctor assesses that they're going to have a poor quality of life or they're going to be in a permanent vegetative state. And some people are really specific about that, and you can also put those limitations in your power of attorney as well. So you don't have to just appoint someone to make every decision and leave it all up to them. You can sort of put in some instructions for your power of attorney, which is great.
Yeah. I couldn't imagine leaving, all the decision making to one person and then not give any caveats or instructions. So that's good to know.
Absolutely.
And so what happens in a circumstance where somebody doesn't actually appoint any powers of attorney, whether that's medical or financial?
Yeah, so look, it really depends. If that person then needs a decision made on their behalf, it gets really tricky. And we often see this in situations where parents don't make powers of attorney, and then they might have an accident or a fall and they need to be rushed into care. And then you've got children usually saying, oh, look, we're not sure what to do from here. Mum or dad didn't have a power of attorney. And the only option for that person is to make an application to VCAT, which is the last thing you want to do when you are stuck in that situation where usually decisions need to be made pretty urgently. Yeah. So what happens is it's pretty self-guided on the VCAT website, but you fill in an application. You have to submit, it's 3 months or more than that of medical history of that person. And then it's actually up to the VCAT member who they appoint as the guardian or administrator of that person. So the bad thing about not having a power of attorney is that it's out of your control. So if something does happen to you and you haven't appointed an attorney, VCAT gets to choose that. And they may choose an independent organisation like state trustees as opposed to maybe a child who you have a really close relationship with. So definitely vital to get a power of attorney in that situation, just to avoid the stress and sort of the heartache involved with making an application to VCAT. But it's not the end of the world. It still can be done. So it's really important for people to know that there are options.
You did touch on that, usually a catalyst occurs for a family. Say mum falls over and breaks a hip and then is in hospital and deteriorates but doesn't have a power of attorney. If someone had to go through VCAT, how long would that usually take?
Look, it really depends on the circumstances and how much evidence VCAT requires before they can make that order. So they are obviously sensitive to the fact that usually these issues are, under strict time constraints and they need to happen pretty quickly. But if there's a contested VCAT application, for example, you've got siblings that might be arguing over a parent's care, those applications can get pretty drawn out.
Yeah. Okay. I have a couple of community questions, if that's okay.
Of course.
The first one is, I am an only child and my mum sadly passed away 12 months ago. My dad needs care urgently but doesn't have the capacity to make decisions, nor does he have a power of attorney. What do I do to help him? And I guess we just spoke about that, but maybe if you can explain a little further about that.
Yeah, absolutely. So that's a perfect example of where I would be saying we need to make an application to VCAT. Or whether or not, if he's got care urgently, I would certainly be recommending that he speaks to medical professionals regardless. Usually there's some kind of intermediate assistance that they can provide, whether that's respite or is in hospital or something like that, and they'll give you a little bit of leeway. But certainly that VCAT application is going to be critical in that situation.
Yeah. So in that situation, it would be appropriate to possibly put him in respite if he has an ACAT until that situation gets sorted out.
Exactly right. And then that gives you scope too. So once you've been formally appointed, then you can look at signing more formal contracts, whether that be with an aged care facility or whether he goes back home or whatever the situation may be. At least that way, then you've got the legal authority to start making those decisions, and the respite is kind of that in-between period for him.
Sure. I have one more question for you, and community who are watching with us live, please do ask your questions in the questions and comment section below if you would like to have them answered. This is a really good opportunity for you to speak with Renee. The next question is, my mum has moderate dementia. She is very confused and we can no longer look after her at home due to her behaviours. She knows that we are touring aged care facilities as we take her with us so that she has input into the decision. However, she always tells us that she will never be put in a nursing home. My brother and I have joint medical and financial power of attorneys and are both on the same page that she needs care. She's unsafe as she is. Are we allowed to put her into care even if she doesn't want it, yet it's in her best interest?
Yeah, so look, obviously that's a really sensitive question, and it's more common than not. Um, if they are appointed as powers of attorney, yes, they do have the ability to make that decision.
Yeah.
However, in the decision-making process, I would definitely recommend that they get an ACAS assessment, or an assessment from a suitably qualified professional who says, yep, look, she does need that higher level of assistance, whether home care is not enough or whatever the situation may be. After they've done that, I would obviously recommend that they've toured facilities, which they have done. So get copies of contracts. You could even go so far as getting some legal advice on those contracts. And certainly what I would be recommending is they get some financial advice too. So whether that's from a financial planner or an accountant, just to make sure that their mum is able to afford it, or whatever the Centrelink assessment is going to be in that situation. And then, yeah, despite the fact that, you know, mum doesn't want to go into aged care, they still have the power to do that. And then it's really difficult because those attorneys often have to manage that relationship with their mum there. Respite is a great opportunity for a transition period for those types of people. It kind of gets them to get the sort of feel of the aged care facility before kind of going through that permanent full-time contract. But when it comes down to that relationship, you know, that's why it's super important that people who are appointing powers of attorney are having these conversations with their kids, so that, and the attorney's aware that what their obligations are, and that, you know, you shouldn't carry guilt if you do have to make those types of decisions where it's for the safety and well-being of your parent.
It's easier said than done though, isn't it?
Absolutely, it is. Absolutely.
In the question, it said that she no longer has capacity to make these decisions. Does incapacity have to be proven before a power of attorney can be enacted, or is it simply a little more complicated than that?
Yeah, so it depends on the power of attorney. So some powers of attorney come into effect immediately. So as soon as they've been executed by the principal and the attorneys have accepted by filling in the statement of acceptance, that power of attorney is immediate. Other powers of attorney, the principal may put in a condition there that a doctor might certify that they've lost capacity, for example, before that attorney comes into effect.
Mm-hmm.
Usually, it depends on the circumstances, but sometimes we would recommend powers of attorney coming into effect immediately, because then the attorney can avoid that hurdle of going to get that letter in the event that they needed to make a decision quickly. Sure. But in other situations, the principal might be quite young. Then, you know, they might be a young family and have control of their finances, and it's only there really as a backup measure for the time being. And in that case, they might stipulate that limitation. So definitely check the terms of the power of attorney, and that'll kind of give you an idea of which way it is.
Sure. And then in order, again, to measure the capacity, it has to be a letter, does it? Or is it just a diagnosis? Or does that, again, depend on what's specified?
Look, it's always dependent on what's specified. It's usually not. It wouldn't usually say something in writing or just a diagnosis. For the attorney's sake, I would definitely recommend getting it in writing. It's always good to keep really full records of everything that you do as a power of attorney, even if it's day-to-day transactions. If you're paying bills or getting assessments, you should really have like a spreadsheet or something like that going, where you're keeping copies of receipts. I would definitely recommend that for any attorney. And certainly with VCAT, if you know, you're subject to a guardianship and administration order and you're appointed the guardian or administrator, you actually have to have your records audited annually. So, and you have to submit all of that financial paperwork to VCAT. So there really should be no difference there. An attorney should be keeping records, and that protects the attorney as well. You know, in the event that a sibling asks a question or something comes out down the track, it's really good that they can kind of produce full financial records for that person.
Yeah. I guess, speaking from experience working with Aged Care Ready, when we have clients who clearly don't have capacity but desperately need the care, and we're dealing with families, and it's such an emotionally charged time, what I have done is referred to geriatricians. So that's where the family goes to the GP gets an official referral to a geriatrician who specialises in aged care, and then they can do that capacity assessment. And I guess from a family standpoint, that gives them a bit of reassurance as well that they're doing the best thing for their loved one.
Absolutely. Yeah. Couldn't recommend a more perfect example of how an attorney should act in that situation. And it's hard because people are stressed in that time, and the last thing they want to be doing is making an appointment with someone else. But in the long run, certainly. And it just gives them a little bit more guidance and surety, especially if the parent is kind of on the border. I mean, some powers of attorney, you might just have an elderly parent, but you still get along with them and you can still do their banking and they still have capacity and you can still act in and access their accounts and do what you need to. Just they might not be as mobile as they once were. Where people lose capacity, obviously, that's when it kind of goes to that next level and they just need to be a little bit more thorough.
And I guess also if you're so close to the situation, you may not see it so clearly that, yes, mum or dad is lacking that capacity, whereas it might be quite obvious to an outside party. And that's where it's also good to get that external assessment done.
Absolutely. Look, and it's really hard. We have people call us all the time, attorneys, for example, or children on behalf of their parent and say, look, mum's about to go into a home and she needs a power of attorney, but usually by that point they might be either suffering from dementia or it's too late that they they don't have the requisite capacity to make a power of attorney. So it's important to know the attorney can't create that document for you. It's got to come from the principal or the person creating the power of attorney themselves.
Yeah, I have heard of that happening before, and I guess that's probably just a way that's, trying to get around the whole VCAT situation, which often looks worse for them than is necessary.
Yeah.
Okay, was there anything else that you wanted to add, or is there any other questions from the community? If you do have a question, do pop it in the comments section below. But was there anything else that you wanted to add, Renee?
No, look, I think we've covered it. They're obviously important documents to do. Everyone's different and everyone wants to do them at different parts in their life. But like I said, and as we sort of touched on earlier, people don't realise the importance of powers of attorney until it's too late.
Yeah.
Look, it's certainly something to keep in the back of your mind. Hopefully both attorneys and principals get a little bit of clarification from this today, and people kind of can make up their minds as to whether or not it's something that suits them.
I think, if anything, it really outlines the need for that conversation to be started sooner rather than later. And it's not because you're expecting something bad to happen to mum or dad, but it really ensures that you understand what their wishes are. And, if something should happen that's an emergency situation and they can no longer speak for themselves, that you're fully aware of what their wishes would be.
Yeah, absolutely. And I mean, with powers of attorney too, obviously it's up to the donor who they appoint, but they can always appoint more than one person. Or, if you feel like your mum or dad has a conversation with you and you're like, oh, look, it's too much to bear, I work full time and it's just a lot, there's always an option to be appointed with someone else, which helps ease that decision-making process a little bit. And that can either be a joint appointment so that you both have to make decisions, just like that question from before.
Yeah.
Or you can be appointed jointly and severally. So one day you might be able to act and the next your sibling, and you both have the same power, but you both don't have to be there at the same time. And that kind of provides a bit of a checks and balances system too.
So how would that work, for example? And I'm just throwing you a bit of a curveball here, sorry, Renee. How would that work with siblings who don't see eye to eye?
Yeah, so it depends on the appointment. So if it's joint and several, usually by nature of these situations, there is usually sort of someone who will take over the day-to-day affairs of mum and dad anyway. That person, I mean, again, they both, despite the fact that they don't see eye to eye, they both have that decision-making power. So it still needs to be a conversation that needs to be had with the parents, particularly if it's a big one, like selling a house or moving into aged care, but they do both have the power to make those decisions. And that's potentially a risk with a joint and several appointment. If you appoint them jointly, even though they don't see eye to eye, they still have to make that decision together. But again, it may cause a stalemate, which is where appointing one attorney at a time might be better. So, if you know that your kids are, don't necessarily have the same ideals, then that's when we sort of speak to clients and say, okay, well, here are your options to kind of avoid that. And normally, a client will gravitate towards a child for, they might have a child that's a nurse, for example, and they're like, look, I think it's a great fit to appoint them as a medical power of attorney, or the opposite, So that's going to come down to your family itself, and it's great to have that conversation. That's all I can really stress enough. And everything that's going on at the moment with COVID-19 has really brought this to light too. A lot of people are wanting to have this conversation more, and whether that's surrounding powers of attorney or wills, which I think is great. A lot of people avoid it. They don't want things to happen, or they don't want to preempt their death and things like that.
Well, it's a hard conversation, as you can imagine.
Absolutely, but it's such a critical one. Yeah.
How old do you think you should be when you have a power of attorney appointed? Is it something that you should be looking at when you're younger, or is it more, 40s, 50s, 60s, 70s?
Yeah, look, absolutely. There's no right or wrong age. That's going to come down to your family dynamic. If you've got young children, for example, and your finances are set up in a way where one person might hold all of the assets and the other doesn't, certainly a power of attorney is going to be critical, because in the event that something happens to the person who holds most of the finances, they're going to want to have appointed an attorney so that they can still pay for school fees or manage their children or whatever the situation may be. So it's not just for older people, it's not just for grandparents. Certainly young families, it can be really relevant too. So, but I mean, the things that become more difficult with a younger family is, who do you appoint? Sometimes people appoint parents because they still have that relationship with them, and especially if their kids are minors. And we can put backups and provisions in place in the event that something happens to that first attorney, and an alternate can sort of stand in their place. So,
okay. Great. Well, if any of you watching us, any of the viewers need some further information on powers of attorneys, feel free to give Renee a call at Beaumont Lawyers. Otherwise, there's no more questions. Thank you again for joining us tonight, Renee, in your home time. And I'm looking forward to seeing the rest of our viewers next week when we talk about our next subject. So all stay safe and have a great night.
Thanks very much for having me.
Bye.
Bye.